a concept of consent, and then there is a deemed consent. What are the practical implications now of this distinction?
So, this is one of the, and now I'm going to put this on Justice Sri Krishna's head, because I think he started this trend, which is defining terms which are understood in the global data protection parlance in a new way. And that's what we've done with this concept of deemed consent. This is nothing new. This has been in the law for a very long time around the world. I can point to the provisions of GDPR and even before that has this. So Justice Sri Krishna rechristened data subjects and called them data principals, rechristened data controllers, called them data fiduciaries. This law is rechristening the concept of legitimate purpose and of reasonable purpose and legitimate interest as deemed consent. Now, around the world, it is well recognized among data protection practitioners, people who are actually doing the nuts and bolts of this, that consent cannot be the only grounds for processing. One of the failings of our law was that we had too much of an emphasis on consent as the primary, and I would argue in later drafts, the only ground for processing. But as a matter of fact, there are various instances where reasonable processing is accepted. If you look at the illustrations that are provided in the law, the illustrations talk about the fact that if you call a restaurant and make a reservation, there is a deemed consent that information that you gave, which is your telephone number, can be used by the restaurant to call you back and say, look, yes, your reservation's confirmed, or it's cancelled, or where are you? And you can't, as someone who has voluntarily provided your number, go to the data protection authority, or in this case, the data protection board, and complain that your privacy has been violated because the restaurant called you to tell you that your reservation is cancelled or whatever. Now, that's one example, but there are many such examples of what the data protection world understands as the legitimate interests. And this is something that anyone who's been in the field actually found lacking in all our previous provisions, because it then makes a lot of what we take for granted completely unworkable. And none of us wants to have to provide consent every minute of the day for every single thing that we're using. And this is what the law from GDPR onwards recognizes, that this is the way in which the data protection laws actually need to work.
But Rahul, just wanted to understand, look, they've put in sort of, again, it will be notified that what will be in the deemed consent universe, a legitimate purpose or fair and reasonable. What can be sort of reasonably expected to come out of this? And do you see any, let's say, exploitative fears coming true when you talk about deemed consent here?
I mean, I think the problem really is that we're using this word deemed consent, because deemed consent sounds like you are usurping my autonomy and assuming consent on my behalf. But if you look at the way that clause is drafted, and if you look at the substance of the provision aligns much closer with the concept of legitimate interest. And if you are to interpret it on the basis of the substance, I don't have this fear. If you are to interpret it based on the title, which is deemed consent, of course there is the fear, because it sounds deeply creepy. But I mean, and this is the reason why I started out by saying, and I'm sure if he's listening, he's going to be very upset with me, that Justice Sri Krishna started this trend. We started calling things in India these new terms, and as a result, we have got to this point where instead of recognizing internationally acceptable terms that we can then reference, jurisprudence, cases, interpretations from the ECJ and things like that, we're now stuck in this place where we're going to have to, people like me are going to have to come and draw parallels between this in terms of art to try and say this is what was meant. I just wish we could make it simpler.
But the government always had the option. I mean, they have veered away from a lot of Justice Sri Krishna and even the JPC recommendations. So nothing stopped them from, if you really think that, this language was problematic.
To be clear, I can't really blame Justice Sri Krishna for deemed consent, because that was never in his conceptualization. But I'm just talking about this idea that we've had ever since that first draft, that we can define things in a new way when we don't need to, when there are standard terms, terms of the art that exist in data protection. So look, this is the other concern I have, Payaswini, with this. We are, as a country, really grappling with data protection because we're taking baby steps. We haven't even learned to walk. At this stage, We're making rudimentary errors like naming things in ways that no one in the world does. Now, these are the sorts of mistakes that we will make as a nation that is just starting out with data protection. And from that perspective also, just to go back to your first question, I think a simple draft is what we need to get us going. I wrote on social media some time back, this is a data protection law on training wheels. And this is exactly what we need at this stage. If we can make it principle-based, we can ratchet up the compliance, we can ratchet up all of the other provisions as we go along. But to start with a extremely complex GDPR type framing would be very, very counterproductive at our stage of development.